Just tell me real quick, because I gotta swear you in and explain your rights.
Well.
Hang on,
You,
time out,
and then.
time out. In 2024, you don't pay your court costs?
Paid today, I wasn't aware I ordered it.
That's 24F243102. You're to pay that when you leave. Your name
Linda Lucas.
and your name.
Gospel A.
You guys are father and son and you're suing one another, my lord.
Unfortunately.
What is happening in this world? See, the property transfer, you say the property transfer financial payments not made. I don't know what you mean by that.
What it is, Your Honor,
Just tell me real quick, because I gotta swear you in and explain your rights.
well, we bought a property jointly in Hungary back in 2009. I maintained it, I paid for it, and then finally, our 50%, since we are older, we tried to transfer it to him. My wife has left over 25%, I had 25%, but I made a condition that he pays me $450 a month fee. And then he didn't do that, and then I went to his house, I said, I go to
What in the world?
$350.
Hang on,
You.
time out.
And then.
Time out. I'm not even sure you're in the right court. If this is over property in Hungary,
Yes,
Jesus. Okay, let's just slow down.
slow down, okay,
If you're going to proceed in the small claims division, you're giving up rights. You're giving up the right to hire a lawyer, demand a trial by jury, appeal my decision.
I do,
You give up those rights?
I do,
You give up the right to seek in excess of 7,000?
I do.
Mr. Lukacs, you understand those rights?
I do.
If you want to preserve those rights, just tell me, I'll remove the case and you can go to I'll still preside, but it'll be in the general civil division. You can appeal, you can hire a lawyer, demand a jury trial. Do you understand that?
Yes, sir.
You wish to give up those rights?
Yes, sir.
Ma'am, do you wish to give up those rights?
Yes, sir.
Anybody force you to do that?
No.
Anybody force you to do that?
No, sir.
Anybody force you to do that?
No,
Raise your right hands. You solemnly swear affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole truth, so help you God. Mr. Lukacs? Mr. Lukacs? Ms. Lukacs? All right, let's start over.
Okay.
So you guys, you own some property in Hungary, right, Mr. Lukacs?
may I read it to you? Or I'll give it to you so you can read it quickly. I summarized everything here,
Whatever you want to
make
do.
it simple for you.
Well, I know, but he needs to hear it. Have you given him a copy?
Right here is the copy.
Give me the original then. Let me take a look.
Take a look at it.
And Mr. Lukacs, you want me to read it to you, sir and ma'am? Or do you want to review it yourselves?
I can review it this way. He left a copy of this in my wife's windshield a couple days ago. There's nothing relevant in here I looked it over.
That's not in your windshield. This is, I wrote this up as a summary. For the judge to read it.
So you agreed at one point, did you, to pay him $350 a month?
Yes,
I'm asking you.
No, sir, there's no such agreement.
Any of this in writing?
Your Honor,
Is any of this in writing? Did you guys put any writing together?
No, sir.
not the $350,
What's that?
not the $350.
Well, then how am I gonna give you that money?
Well, because on his word, Your Honor, he took over my company since 2013 for $360,000. He paid part of it until 2019. He still owed the $240,000 he never pays. On his word doesn't go nowhere. And I wouldn't be here asking for $350 today if he honors the date. He took the money out of my own company, $500,000 receivable, $58,000 assets, and he's still using those today. And he left me dry. I only live on Social Security.
Yeah,
That's why I had a problem with 350. I would need it otherwise.
you don't owe him the money?
No, sir. This is his third attempt of harassment on me. The first one was dismissed, last one was dismissed last year with prejudice. This is now the third time.
Was that in front of me?
Yes, sir.
Were they both in front of me?
No,
The second one was, I listed the case numbers on I filed a motion to dismiss. The second one, 185, 205,
Hang on.
the case number. This is just an ongoing harassment I'm getting.
Did I rule in his favor before on this, Mr. Lukacs?
no, I dropped up. We had an issue with a joint car, and that's what I was here the last time, and I dismissed that case. That's it. I never been here before on any case with him.
I thought he looked familiar.
Yes, he tried to, this is the,
Jennifer, they have another case in front of me?
Judge, not that I'm aware of, is there, let me,
No, did they, like a year or two ago?
let me pull up.
it's listed in my motion, 2025-25-00344 SC. There's another one in 2021.
Where is that for?
That was also dismissed.
What is that for?
It's your case, I don't know.
Tell me.
I entered some dismissal with prejudice on 2025-25-00344-SC. I entered that on April the 8th of 25.
That's the
And I'm
only one
pulling
we
it
had.
up.
That's the only one I had.
And you,
This is so
And
sad.
that was over
How
a
old are you?
Mercedes, Your Honor. That was not over property.
It was over a what?
It was, the complaint and indicates it was over a 2004 Mercedes.
That's the only one, yes.
Well, that's not the same as here, is
it's
it?
not the same case, but this, it's always something different. This is now another angle that he's trying to harass us with.
Yeah.
You don't have anything in writing.
He's been in court with the union, local aid union for $1 million judgment.
I don't care.
And then he tried to implicate me.
You don't have anything in writing here where I can grant this relief for you. How am I supposed to know this?
Well, because he promised it. That's what my wife signed it in September. He made my wife sign it. I refused to sign it until October. And he had me over with the video conference. His wife was over there. I hand him a check, a copy of the check, went to deposit this money. My wife went back about a couple of weeks later.
You guys, this is sad. This
And he
is sad.
told her he's gonna make up an agreement. That agreement never happened. Needs the money.
It's still, I don't care what you guys tell me, it's still sad. I don't think I can give you this relief. I don't know how I can. You got nothing in writing for me, sir.
Well, people make promises, right?
Well, I get it, but
I just heard you talking about all these cases. Everybody was talking on what I heard, what I said. The guy on the video said, you believe what he was saying. I'm not here to lie. For us, it's a must money because our living expenses is beyond our income. He can return the property, Your Honor. Just give it back to me. Very simple.
I think this is so sad, you guys.
Not only that, he changed the keys on the house in showroom, so we can't even get into
Did
it.
you do that?
I'm sorry?
Did you change the keys, the house key?
We did because we had all the family members that were getting in there, so it's been changed, but my family there has keys. They maintain the property, he has use of the property if he needs to use it. It's
But
getting currently renovated right now.
Mr. Lukacs, I'm sorry. You don't have enough proof here. I'm gonna have to find for the defendant no cause of action. I'm sorry. There's just not enough here. You can go down the hall and get a copy of this small claims.
With prejudice again.
I'm entering a judgment and no cause of action.
Okay, thank you.
Thank you. Good luck.
here's that, sir.
please. It's a swivel. There you go. Tell me your name. Mr. Lilly, your name?
William Lilly.
Sorry about this. I truly am. Ma'am, your name? I've sworn everybody in. You're all under oath. You can tell me what you've discovered now, Mr. Lilly.
Okay, I found the invoice, and it was actually, like I said, for 2 jobs. It was a caulk job for $400, and it was one for tearing out the existing 4-inch drain tile and replacing new with the adjusted pitch for $3,300.
All right. And you're telling me that that was the problem with the French drain installation. There wasn't enough of a pitch, correct?
There was actually a couple different problems. Like I said, none of the attachments were attached. Couplings, 90s. Yeah, and the drain was wrong. The pitch was wrong.
Do you want to ask him any questions, Mr. Brooks?
Dude,
Okay.
what qualifications do you have for being an expert in drainage systems?
Actually, I don't have a lot of experience, but my family, they've been in landscaping probably about 20 years or better.
Okay. And you said the reason that you believe the drain was not working was because it had no pitch? And
It
then it
didn't have
was
the
not
right
fluid?
pitch. Yeah, the pitch wasn't correct.
Okay, and you're familiar with the type of pipe that was used?
I am.
What type of pipe was that?
It's got holes all in it. So the drain, again, sort of go into the drain water, into the groundwater. And if it overflows and you get a really, really heavy rains, then it should flow down that pipe. And it was never flowing down.
Okay, and that type of pipe is commonly known as triple wall or ADS pipe?
I'm like I said, I don't have that knowledge of exactly what it is and what it's called.
I'm just
A lot
wondering
of people
because
might call it PVC. Excuse me.
Because that type of pipe does not require glue per manufacturer's recommendations. It's bell and spigot fittings. And you're claiming that it didn't work because it wasn't glued.
Okay. So then when we dug it, the fittings themselves were separated. What would you do there? If you're the professional, what would you do there? Wouldn't you make it to where that doesn't separate?
I wouldn't be surprised if it was separated if it was dug up, because it would be nearly impossible to dig it up without separating pipes. Unless you're using some very delicate equipment, which there would be no reason to do that. The other thing I want to ask is what type of instrument you use to determine the slope.
Again, we put ground levels on where it was dug. You could see, as soon as we uncovered it, we put them levels on there. That bubble was almost completely flush. Now, if you want to talk about building or carpentry or any kind of trade business other than that, I am a professional.
So you're saying that you carefully excavated the soil above the pipe as not to disturb it, and then checked it with a level?
I'm sorry, it's kind of hard to hear you. Can you say that once again?
So you're saying that you carefully extracted the dirt that was on top of the pipe without disturbing the pipe and checked it with a level, like a 4-foot level?
No, there wasn't no dirt there. It was all big rock, probably as big as, a little smaller than baseballs. It was just all backfilled with rock.
So you extracted the rock very carefully without disturbing the pipe, and were able to check it with a level?
No, we didn't have to disturb the pipe. We uncovered it, and then again, when we put the level there, we let the lady know. The lady brought it to our attention, so we just dug out a little bit and showed her that, look, these fittings are separated. So again, that's only going to go as far as that pipe is. If it's a 10-foot section, it's going to run through them holes into the groundwater, or into the ground, should I say. Nothing's going to flow through there, even if it was a major rainstorm, which she has video of that. So again, that was on a bed of dirt, but it was covered with big rocks. The hole, I would have to say, approximately 3 foot wide by about 30 feet long before you go down into the main pitch, which would be, I guess, the side of her garage where it dips down, and it's got a pretty sharp angle. And even there, at the very end, never got no water out, I guess, when she flushed it. And I explained to her that, again, the pitch was wrong up there, it could be wrong here. So we redug it, the pitch was right there, but again, there was 3 sections there that was just completely separated. So if you have a pipe that's connected here, and you're letting that groundwater just run away from there, it's supposed to run down that pipe if it gets over flooded. And it doesn't make it all the way through the holes. It's backed up more or less because it's such a heavy rain. It should flow down there, and it's not going to because it's only flowing out the end of that pipe. No connection. It's going to carry it in sections.
So you're saying that since she put a hose in it and tried to flush it, she should see water coming out the end of it?
I wouldn't say hose, no. A hose isn't accurate as for like a rainstorm. That's what it's there for.
Well,
To
you just
divert it
said
away
that-
from her neighbor's yard.
I know I
What's
heard
that?
you say that she put a hose in it and tried to flush it and didn't see water coming out of it.
I never said that. You can check the court recorder. I never said that.
What'd you say, ma'am?
I gave you a picture of a hose by one of the drains, and I let it run for 5 minutes, and it never came down to the pipe.
You could do that for hours on end. And now that I'm thinking of it, we had this.
Were you on this job at all?
No, but I got enough information to know what's going on.
And what do you think happened? What do you think happened?
I say things like texts. I did get a call from her, and her complaint was not that the drain was not working. It was a picture of 2 bricks that were underneath the fence that had sunk a little bit. And she asked me why the bricks sunk. I said, I don't know, probably because it's a very wet area, and that's why I put a drainage system.
I gave you the Texas on too.
And I do.
I see which bricks you're talking about, just right of the German Shepherd sign, right?
Yeah,
Yeah, that's what she texted me about.
and then somebody said that there's an issue with the water, but that's why I got the drain put in. If the water's gonna sink everything, what good is the drain doing? It's not doing anything.
What about that?
No, I mean, there's a driveway and there's a bed and there's a bunch of water coming from everywhere going in this bed of rocks. So we put a drainage system. The fact that I believe she asked us to put these bricks underneath the fence. Probably not the greatest idea ever, but we did it. And because that area is so wet, there's no way to like properly install bricks like that underneath the fence. It was kind of like a afterthought or something to make it look nice. He kind of contacted me about why they're selling. I said, probably because it's a wet area.
Did you contact them before you contacted Mr. Lilly?
Yeah,
And what did they tell you?
they didn't wanna be bothered. Somebody told me they don't have time for this, and hung up. Then they sent me I believe you have a text, because they wanna put in drains and get some yard ready for winter.
Has this been working since Mr. Lilly did it?
Yeah, water comes out.
That's not the type of drain we put in. It's a perforated pipe. The water, you could stand there with a hose all day. Because it's got gravel and the water comes down and it doesn't all solid pipe all the way to the end. It's all perforated. So you can stand there forever with toes. The only time it would ever come out of the end is if it was like torrential downpours for days on end.
But there was so much rain,
That's what it's
stone
supposed to go off.
actually covered one drain.
All right, here's what I'm doing. I'm getting off this bench for 90 seconds. I need to take a break. I'm coming back. I'm listening to what everybody else has to say one last time, and then I'll tell you my decision, okay? Everybody stay seated. Sit. No, you're right there. You're good right there. John. I hate to do this to you guys. I'd really like it if we brought in the guy who did the work on this, Mr. Brooks. He still works for you.
Well, the guy that designed the drainage system, the guy that, put it in, does not.
Are you friendly with him? Can you get him here? I'd like to hear from you. Is there a problem?
Well, yeah, I mean, this is the third time I've come for this frivolous lawsuit. This is.
Well, I don't know if it's frivolous or not.
I do, because.
Well, wait a second. Wait.
That didn't work.
Wait a second.
Water.
Wasn't one of your witnesses gonna have, why'd I adjourn it the first time?
Because we got to the point.
No. I thought I did. Hang on. I think I adjourned it because one of the people was gonna have a baby or something like that. I think that's what I did. And it was one of your witnesses, right?
No, he was, yes, that was.
Is that true or not?
No, you didn't adjourn it because he was gonna have a baby. You adjourned it because she started talking about this guy that knows everything about drains and you wanted him here. And we were gonna reschedule it, but it was gonna be a day about when his baby was due. So we pushed it out like another month.
Is that Mr. Lilly?
No,
I ain't had no babies. I'm 59.
he's not the baby guy. My guy's the baby guy. So,
Yeah, but you're so good looking. I thought you were dating a 28-year-old woman or something. I'm just kidding. Listen, wait a minute. Listen, I'm just asking you if you can get the guy here. Yeah, I got an expert on this other side here, supposedly. He says he doesn't do a lot of this, but he's been in landscaping. His family has. He sounds like he knows what he's talking about. And he says you did something wrong. You might believe it, not believe it, agree with him, not agree with him. I don't care. I'm just asking, can you get the two guys here?
No.
You can't?
I mean, theoretically, I might possibly be able to track him down, but I don't want to. I know just about as much as anybody else. I mean, the guy that.
You weren't even there.
Well,
You don't even know the work that was done.
no one's ever said to me, this drain doesn't work, look at the water sitting on top of it. Like, it's a drain, this isn't like something complex, like, there's a million pictures.
Cover a drain.
Water is not gonna move
Wait,
the rock.
Wait, guys.
Like, this,
wait.
like, she's talking about a stalker coming and taking the drain apart.
I didn't say he took it apart.
What'd you
I
say?
said he put something in there.
She's
But there was nothing.
Calling me a stalker, dude?
A stalker coming and
Guys.
plugging up her drain, like.
Guys.
He has done this for 18 years. He does a lot of new things.
What else did?
Guys. It's 3:20.
This is the third time I've been here, I don't want to come before time.
I'd like to go back to work.
Dude.
Boy, since I got a mutiny going on here, John.
I like to do a lot of things.
I'm just saying, Ron, this is taking a bunch of my time and I got a whole house I gotta do. My drywall mud is in my pen and it's already starting to stiffen up a little bit. So I like to just get back to work.
Hang on a second. You
Okay.
were subpoenaed. You don't get to
Okay.
dictate here, Mr. Lilly. They
All right.
gave you a subpoena. That's an
I got-
order to appear.
Yes, sir.
I don't want to hear from you and I don't want to hear from Mr. Brooks over here anymore, okay?
You got it.
All I know is I'm left with two unescapable facts. One, you put this in, and two, she had to have it redone. And she claims there's nothing wrong, there's no problems that existed now that existed after you did this. So I don't know what to tell you. Something that Mr. Lilly did created satisfied or rectified the issue. So I can only conclude based on that you didn't install it right. So I'm sorry. I mean, I was trying to help you and I'm not trying to penalize you, but I was going to give you that opportunity and I just can't. $3,600 I'm going to award judgment for plaintiff and you have to pay the court costs. What are those, Jennifer?
Judge, I'm pulling them up. I know she had some service fees, so give me one moment.
So I'm going to enter judgment. They got an $82 and
A little bit.
It looks like that might be it. So it's $3,682. I got a
It looks
judgment
like,
for me.
Judge, there was a $68 service fee back in October for
So
personal
that was
service.
$3,750. Can you pay her today, Mr. Brooks?
No.
When can you pay it? All right, so you're gonna drop a check off to her house tomorrow?
No,
I'll tell you what. You mail it. I'm just gonna say you have to pay it to plaintiff in full by March the 20th. So you put it in the mail tomorrow, she'll have it by March the 20th. Thank you all. I'll give you all a copy of the judgment. You can go down the hall and get that. I'm taking back and giving everybody, John, give everybody back the photographs. Thank you all. Lukacs,
Thank you, Your Honor.
Laszlo A. Lukacs versus Laszlo Lukacs and Linda Lukacs, 2600415. I also have a balance to pay. Who's Laszlo R? Where's Laszlo R? Your name?
Laszlo R. Lucas.
You owe the court $248.
I do.
People against Lexi, Jane, Elaine, Dan. 25B724898. Good morning, counsel.
Morning, Your Honor.
Your appearance?
James Jeremiah on behalf of Ms. Dan, P 60260. She's present by laughter.
Ma'am, your name?
Lexi Dan.
So I want to make sure, my notes were not very clear here. It looks like, first of all, she was charged with 3 different counts. She had OWI occupant second, less than 16, which, as you know, is a 5-year fine. She also had 2 other counts, which were consisting of, let me just give me a second here. Which consisted of a charge of OWI second. That was set forth in count 2, which was also, it was actually a high BAC, OWI high BAC set forth in count 2. And then she also had a charge of operating while impaired second. As far as I can tell from my notes and everything here, she pled to OWI occupant less than 16, a 1 year. The felony count relating to the OWI occupant, as well as the super drunk. And Heather, I want to make sure that everything is reflected accurately. I did not make very good notes on the register.
Beth did come down this morning and
Right.
speak with Lisa about it, so I believe everything should be correct in the system now.
Right. So I also had, but I want to be clear about this. So count 1, there was a plea to the lesser included of OWI occupant less than 16, a 1 year. Count 2 was super drunk second with the prior, which is also a felony that they went ahead and dismissed. And then count 3 was operating while impaired second, which they also dismissed, but a count was added of child abuse in the 4th degree. So I'm going to sentence, which is also a 1 year. So I'm going to sentence on the OWI occupant less than 16 and child abuse 4. I'm going to put it on our sobriety court register as to OWI occupant less than 16. The terms are going to end up running concurrent as to that charge and the child abuse 4th, and then all other charges will be dismissed. That being said, have you had a chance to review the report? Do you agree with all of that?
That's correct, Your Honor. It's double checking. Yes.
Yeah, I mean, I just, they did this on a little bit different form because it was sobriety court. And, that's it. That's all I'll say about it. I did, then, for the record, a victim's rights notice was sent to Mr. Hughes. I believe it's Mr. Hughes. Just give me a second. Yeah, Josiah Davis, care of Forrest Hughes. Is that individual here? That individual is not here. You can go ahead and proceed. Have you had a chance to review the report, and are there any material additions, corrections, or deletions?
We have reviewed the report. The stand has also reviewed the report. No objections or writings.
All right, anything you would like to say?
Very briefly, Your Honor, I sent, and I apologize, I just gave it to the court today, sort of a bullet point letter. And if the court doesn't have it, I have a copy I could give you right here.
I don't believe I've received that.
I will hand it to the court and I will summarize it very quickly.
Okay, you can hand it up. Thank you.
Because although the pre-sentence report's accurate, Your Honor, the question is, why does this keep happening to Ms. Dan? And I think that's what I kind of lay out very quickly in my letter. She was, I don't want to give you too many details in the report, but she was the victim of some abuse multiple times as a child. And her substance abuse stems not from her desire to party or have fun, but to deal with this trauma. Which will segue into, she's aware of that. She was taking some medication to curb her ability to drink. Then she got pregnant and had to go off it.
The Vivitrol.
Correct, Your Honor. She has, since her arrest on this, been working on her addiction, but I think more importantly, the underlying issues, going to mental health counseling, going to meetings, going to family counseling, going to individual counseling. Talking to her today, she says, every day she has some sort of meeting, some sort of therapy to go to. Recovery for her has been a full-time employment, really. One thing she wanted to do today, but she said she just couldn't do it, is read some letters to her children that she wrote. Those letters were both an apology for her actions, but also an explanation. And I think more than anything, what those did was help her understand the effects that her actions have on her children and how much they impact them. I've received calls and texts and support from her current boyfriend, who she has one child with, or expecting her second one. He's committed to her sobriety and sober living. A very good friend who's been helpful in supporting her, giving her rides, making sure she gets where she needs to go. I think all these things show that she's really committed to her recovery. She appreciates, she's, I think, one of the few drug driving clients I've had that doesn't complain about the tether, the alcohol tether. What she says is, thank God I have this on because I can't use the Vivitrol. It's really helping me stay sober. The court has the option of sentencing her to some jail time on the child abuse fourth. I think given the progress she's made in her recovery, I think that would be counterproductive. We're asking for a non-custodial sentence on that. If she doesn't continue to make these great efforts, the court can at that time, I think, impose a jail sentence. But I think as long as she's working so hard, I think the important thing is to let her continue that.
Anything that you would like to say?
I'm pretty sure that the sentencing began my baby's life. So I just wanted to say thank you for that. I'm really happy that I got caught that day. I'm 85 days sober. I go to a meeting every day. I do everything that I'm supposed to do. And I want to help other women like me once I start going through this program.
I'm sorry, I didn't hear that last sentence.
I just want to help other women like me once I start going through this program.
Well, I'm troubled. I'm going to tell you my negative comments first. One of the things, I've been sitting here quite a while now, and one of the things that I always think of is how do I say this delicately? It's an impossibility our society to improve if we don't have parents that care them. Can't do it. Impossible. And I'm not saying every parent, I'm not saying majority of parents, but certainly there's a sufficient amount of parents out there that don't get it. They don't understand. They just don't understand. You can't have parents that don't care about their kids. Because when they don't care about their kids are smarter than we give them credit for, even when they're 2 or 3 and they don't even know that they're thinking. And they know when they're loved and they know when they're not loved. And they know when people care and when people don't care. Now, I'm looking at this from and I told you I'm going to tell you the negatives part first. I'm looking at this and I'm saying, do you have a young child in your car? And that child at the time, now you've got 5 kids and you're looking for a 6th, right? Right?
Yes,
And the child that was in the car was how old?
it was 2.
Okay. And you were pregnant when you were doing this, right? On its face, the child has no chance. On its face. No chance. I feel so poorly or badly about the fact that so many kids come into this world and they have no chance because they have parents that are not doing the right things. And I didn't say it's an easy job. I'm not sure any of us are equipped to do it, but it's certainly not an easy job. But we have to try. And we can't have kids when we're doing cocaine and hallucinogens and amphetamines and sedatives and inhalants, and now we're smoking marijuana and we're drinking. All of that, you don't need a legal scholar to tell you that. You don't need a substance abuse counselor to tell you that. You don't need a psychiatrist or psychologist to tell you that. You just need somebody with common sense to tell you. Just a little, they don't have to be overwhelmingly intelligent. Now, that's the bad news, because I'm just really floored by some of the things I read in. I really am. We just can't do this. We cannot do this. The good news is, I believe that you're sincere about this. But don't go out of here. And I'm telling you, I'm not saying you're going to be one of them. But I just have sensed, and I can almost see it when they leave the podium. There's either one's boy, I got lucky and I'm going to stick with it, or judge didn't send me to jail. I'm okay. Now I can let my guard down. There can't be any letting of your guard down. If I want you to understand that if you don't comply and make it through sobriety court, you will do a year.
I understand that.
I hope you do, because there will be no ifs, ands, or buts about it. There won't even be a consideration.
I understand.
Now, so far, you've at least weaned yourself off the marijuana. But I'm telling you, nobody can argue with me that alcohol and drugs being consumed by a pregnant woman is anything but horrifically bad for the child. And I don't know how to put it to you this way, but other than saying, I mean, kids are bigger than we are, right? I mean, we should be doing everything we can to make them successful, to make them have values, have integrity, work hard, making them understand the world doesn't owe them a living. Now, I'm going to cut you a break, but I do not want you to walk back from this podium, because there's going to be a lot of requirements here. And I want you to understand, you violate and you're gonna get every single day I can give you.
I understand.
Do we understand that?
I do.
Now, the prosecutor's office, they come out with these things and they wanted me to send you to jail in so many ways. I'm gonna read it to you just to remind you what they said. Sentence agreement of 60 to 90 days is determined by the judge with work release if eligible. May be waived, jail condition may be waived at the discretion of the court if the defendant completes a specialty court program. Court can impose jail at its discretion for child abuse 4. The OWI 3 charges will be dismissed at sentencing. Really, it was an enhanced from super drunk, second, which makes it a felony, child occupant less than 16 with a prior, which makes it a felony. So there was no OWI 3, but they were enhanced and they were felonies. 2 years probation sentence agreement with sobriety, drug, veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination. 33rd District program is acceptable. We think it's more than that. Full restitution, parenting responsibility should be included. Defendant fails out of the sobriety court or court, specialty court due to poor performance, commits another crime while on probation. The judge finds sufficient cause to terminate the balance of the year. 1 year must be served in jail. No work release or waiver. The above are recommendations only is what I made them add. The court need not order 1 year in jail if the defendant does not successfully complete program. And I've gone round and round with them about that because they're not the judge. And they have the right to do what they want to do and enter in sentence agreements, but I don't have to go along with sentence agreements. I thought that was overly harsh, especially for somebody that might struggle and get to the end and violate, and I'm not giving them a year. But I want there to be no misunderstanding. And I know I'm talking a lot because I'm troubled by this one. I want there to be no misunderstanding. You fall down on this, you're doing a year. Your lawyer has done a tremendous job for you. Did I let everybody finish? I'm ready to sentence if I did.
Yes, thank you.
Anything else?
No, yeah.
I'll get the count. I'm going to call it count 3. It should be child abuse. They're not adding a count. They're reducing a count from operating while impaired second, which is a 1 year, as far as I'm concerned, to child abuse 4th. 2 years probation. You cannot leave, but first of all, you have to comply with all agreements, guidelines, and requirements as indicated in the sobriety court participant handbook. 2 years probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs, and you're not to go to any place that sells or dispenses or alcohol. And I'm talking as its primary source of business. I'm not going to consider it a violation if you go into 7-Eleven and buy a Diet Coke, but you're not to go to any bars. You're not to go to parties where alcohol or drugs are being consumed or dispensed. You're to submit the chemical testing, PBTs and ETGs on demand of probation. We're going to pay for those tests as long as you go every single time. And as long as you test negative every single time. You test positive, you're going to end up paying for the test and you're going to be incarcerated. You complete, they're recommending 60 days. I'm going to make it 90 days on the sober link. I know you have a scram. We're going to change the scram to a sober link. It's going to be on our dime now with our grant. You fail the test, you test positive on a test, you're going to not only be subject to sanctions, you're going to be paying for your own testing for a lengthy period of time. You're to attend 12-step meetings 3 times per week and provide written proof of attendance. You're to obtain an AA sponsor. You're to attend all substance abuse treatment at a facility approved by probation. You're to attend the Victims Impact Panel. That is 1 night put on by Mothers Against Drunk Drivers. You're to attend and complete the Armed Specialty Court Weekend Program. You're to report to sobriety court status review hearings with me every 2 weeks. You're to meet with probation in the off week. You're to obtain and maintain employment with proof provided to the probation department. And this is all on count 1. This is all for the OWI occupant. Less than 16, 200 fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So that is 5.25. Your screening fee is 60 for 585. You have probation fees of 480, bringing your total to 1,065. You have sobriety court fees of 360, bringing your total to $1,425. Now, I'm going to order that you serve 11 days jail, credit 1. Actually, I'm going to order 15 days jail, credit 1 for 14. I'm going to allow you graciously to serve 10 of those days on the court work program. There is a $35 a day charge for that. You're going to serve the other 4 days by way of community service. You're going to serve 4 days of community service. I'm going to give you time to complete that, and that won't be, I'll give you all the way until May the 31st. You're going to have your hands full. You're to complete 10 days on the court work program and pay a sum of $35 for each day ordered. I'm going to make a note that that is $350 plus your $1,425. So your total here amounts to $1,775. Now, I'm going to talk about court work program fees in a second. All right. Now, if you violate, your probation could be revoked. You could be incarcerated for a year with credit for 1 day served and any other time you serve on the court work program, community service. Defendant not to be completing court work. You're 5.5 months?
7 months.
7 months, I'm sorry. Not to be completing court work not to be completing or starting court work program until at least 3 months after childborn. Your community service, I think you're going to be able to do one way or the other by May the 31. That's not taxing, and I'm not going to have you start on a court work program now. As to count child abuse, I'm simply going to indicate I'm putting you on the sobriety court for that as well. Sobriety court terms and conditions concurrent. This is on, and I want to make sure it's mentioned there, other sobriety court terms and conditions set forth in count 1 to run concurrent. So I'm basically ordering everything on this case that I just ordered on the other one. However, I am going to add a little bit of fines, but not much. Heather, I don't remember. Can you ask Amy? There's one of these, when it's a state case, we don't charge the victim's rights or justice assessment. I can't remember if I charge the 75 or the 50, but not both. So can you check with her if you don't know the answer, or Lisa, please? I'm going to simply go. So I'm not charging any other fees except to say 100 fines, 100 costs, and then you paid the screening fee. You're going to pay everything else, and I will either charge you 75 for the victim's rights or $50 justice assessment. So your total there is either going to be 275.
I'm checking right now.
Take your time, or 250. Again, if you violate, your probation could be revoked. You could be incarcerated for a period of 365 days with 1 day credit. Now, I just want to double check one other thing. They ran Forrest Hughes is who? Boyfriend?
No, he's a friend of mine. He's just a friend. He just helps me out with rides and getting me.
Well, why did we send the victim's rights? He's not the father of any of the children, is he?
No, we were unsure as well. That's why he didn't have anything to say. He didn't know what to say or what to do. And when he called, he couldn't get a hold of anybody around.
All right.
Okay, Judge,
Yeah.
we charge the 50.
So it's $50, something. So it's the $50 judgment fee, justice assessment fee for a total of $250. So you owe $250 plus you owe on this case, and I can't do much better than this, $1,775. So you owe $2,025. Now, I'm going to let you pay this case, the child abuse. I'm just going to give you a date of May the 1st. Can you do it by then? That's only $250.
I can do that, Your Honor.
And then I'm gonna have you pay, and you can tell me if you can do this. But I need you to stick with it. $50 a week, starting May the 8th.
I need you to say that again, I'm sorry.
50 per week beginning May the 8th. Can you do that?
Yes.
Pay 50 per week on count one beginning May the 8th. And if you ever need more time, you need to come talk to me. All amounts due by November 1 of 27. Okay? You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I'm not taking action on the immobilization since you didn't own the car. There's no evidence that the car owner allowed you to operate while knowing you were intoxicated, and that's what I'm gonna do. You'll go meet with probation. We're gonna switch out the scram. The judge said switch out the scram for Silver Link. And we're gonna have to send a letter to the county because that's where she got it at, Heather. She got the scram tether at the county when the bond was set, okay?
Okay, Judge.
All right, thank you very much. Good luck.
Thank you.
Have a good day. Nice day to your counsel.
Thank you, guys. Appreciate it.
Curtis Brett Hamadi, 26R70167. Lieutenant, your name?
Detective Lieutenant Steve Mercury, Rockwood Police.
All right, so this is Judge Hessen's case. She's not here. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth. So you got it.
I do, Your Honor.
Go ahead.
Your Honor, December 12th, 2025 at approximately 7:08 a.m., officers Christopher LaFleur and Stephen Corn, both with the Rockwood Police Department, was dispatched to the Rebel gas station 22855 Huron River Drive within the city of Rockwood for a panic alarm. Upon arrival, the officers met the cashier identified as Philip Morales. Philip advised that one of his regular customers by the name of Curtis Hamady had come in the store a couple days prior, and when he walked in the store, Philip asked him if him, who was with his girlfriend, asked him if he was ready for the upcoming holidays. The girlfriend replied, "Ho, ho, ho." Philip then told Curtis's girlfriend that she can do whatever she wants in her free time. This comment made Curtis upset, but he immediately left the gas station without incident. On 12/12/25, Curtis came in the gas station, bought 2 large cups of coffee, and as he approached the counter, he got in an argument with Philip over the comment he made about the ho, ho, ho. As the argument escalated, Curtis grabbed the 2 cups of coffee and threw them on Philip, causing coffee to go all over him as well as the store. Philip then at that point said he was going to call the police and hit the panic button. Curtis left the store. Officer Korn reviewed the store video, and it did show that Curtis, who Officer Korn had arrested prior months ago, could identify him as our subject, Curtis Hamady. On 12/12/25 at approximately 8:25 a.m., Curtis Hamady called the Chief Krause of the Rockwood Police Department on a recorded phone line and admitted to the incident at the Rebel gas station. Curtis told the chief that he said he pushed coffee cups that did contain hot coffee towards the Rebel employee. I sent a warrant to the Wayne County Prosecutor's Office, and you have a charging document in front of you.
Based on your sworn testimony, I find the crimes of assault and battery and disturbed the peace were committed. There's probable cause to believe the crimes were committed by the defendant and authorize the issuance of the complaint warrant, $200 bond. Maybe you can call him and tell him to come in the warrants, if Mr. Hamady, I'm saying, and just tell him the warrant's going to remain in effect unless and until he does. And I'm signing the complaint and we'll put it in the lien. Okay?
He's on probation through the court also, so.
Okay, thanks. By the way, I'm changing the date. You sent it over the other day, the 3rd or what have you, and so I'm changing the date on there to the 7th.
Okay, thank you, Your Honor.
Happy New Year, Lieutenant. Have a good day.
Thanks, you do the same.
Harms K. Canoon, 25W840939.
Morning, Your Honor. Paul Young's on behalf of Mr. Canoe.
Good morning. How you doing, Mr. Youngs?
Good, good.
You're going to plead to impeding. You're authorized to enter this plea on his behalf, and they're going to dismiss the speeding, right?
Correct.
To that charge on behalf of Mr. canoeing to impeding traffic, responsible or not responsible?
Responsible.
Is he licensed here or elsewhere?
Chicago,
What kind of record?
clean. I mean, so what I see in there.
Well, you don't have the Chicago, Illinois record, do you?
No, I keep saying Chicago, but I meant Illinois.
Well, I know.
I believe that we share with Illinois. But no, I don't have his Illinois driver.
150 is the total. Speed's dismissed. You're all set. Does he need some time? Yeah, I'll give him till the 14th. How's that? That sounds right. Okay, thanks a lot. Have a good day. Thank you. Jamela Mebane. Mebane, MEBANE 22F237322A B and 22R512824A. And also 22R512824B. Who's her lawyer, John?
Oh, I'm sure. Thanks a lot, I'll zoom in, I don't have it.
I need him.
Yeah. Well, there it is.
All right, I called Mebane here. I have 22F237322A, which is a driveway license not valid. 22F237322B, which is a civil infraction, improper lights. 22R512824B, which is a failure to pay on a limited access. 22R512824A, which has not been adjudicated. That's a no ops. I hope she has a lot of money. She's been playing games with us. Your appearance? Name, ma'am? Your name?
Bay.
All right, so what are we gonna do here? She doesn't want to show up, so she's probably gonna have a high cash bond, if nothing else. On the no valid license, does she stand mute and wait for a reading? She's only missed about 4 or 5 times on this. And then somebody will be a wise guy and say, oh, you sent somebody to jail on a drive while like, well, I don't know what else to do short of tackling them and bringing them in here. What if she's got others, limited access, $306. Does she stand mute? This is on the limited access from 2022.
I think we got the big traveling paper tomorrow for you to do it upstairs.
Boy, you don't have much respect for courts, huh?
No, I actually.
Somewhere between 0 and negative 2,852, it looks like to me. I mean, Judge Hessen's been overly kind. Okay, shake your head. Judge Hessen's been overly kind with you.
Yes, I
Does she
appreciate
stand mute
that.
and wait for a reading on the other one?
Yes.
A guilty plea on that. She has flat rock in front of Judge Hessen, failure to pay. Does she stand mute and wait for a reading on that?
Yes.
Wow. If I had a nickel for every time you missed a court date, I could. She doing? What is she doing? Who does she think she is?
I don't live here.
And give a lot of feedback.
Well, good. Hang on. What's wrong with the, you live in Toledo. You don't live in Juneau, Alaska. Give me a break.
I lived in the
I would quit while I'm behind right now unless you got a lot of money with you right now. Okay? I don't really want to hear it. I don't want to hear it. Tell it to some other judge in some other city in some other state. Where does she work?
Director.
Got a problem.
Makes $500.
She missed April 14th of 22, May 12th of 22. Came in October 12th, or was brought in, I believe. She was given, or at least it was on Zoom, given another date, January 3, 23. She didn't show up then. She was show caused again in June of 23. She didn't show up then. Wow. And that's just one file. That's just one of the files. I don't feel the need to go through the rest of these. All right, Heather, how much does she owe on all of these? On 224B, And, I'm sorry, on 824B and 824, 322A and 322B. I'll set those together.
322A has a balance of 411. 322B has a balance of 248. And then 824B has a balance of 306.
All right, I've got these a little bit mixed up here. I got 824B that has a balance of 306, true?
Yes.
All right. I've got 22F, 237, 322A that has a balance of
411 on that one.
411. She only had 3 files or she had 4? She has 4, doesn't she?
4 altogether.
Yeah, I don't know what I did with the other one. Hang on a second. Oh, no, I see. And what does she owe on 322B?
248.
Where has she been? Is there any valid excuse whatsoever?
Yeah, I don't know, but she moved to a, in 2022, she came back to me.
Forgot about the meters. Okay. I got it.
He does inform that other than he tests, he has no other criminals. Given, put a, that on the file with updated assessment.
Okay. I'm sorry, Heather. 824A, she owes how much?
824A, that's the one that she hasn't been sentenced on yet.
Oh, that's right. So we're setting a pretrial on them.
Correct, Judge.
I see. She zoomed in once, so she wants to make it sound like she lives so far away. She zoomed in. She doesn't need to come in here from Atlanta, but all right. I just want to make sure I got these right. She owes 306 and she has a pretrial on a suspend charge. She's missed multiple court dates. The likelihood of her appearing again is not very good. Judging from what I've seen here, it's nearly impossible to rely on. So on 322A, I'm setting, and that'll cover B as well, 600 cash or surety, 600 cash or surety on 824A. 322A and B are covered together. 824A and B are covered together. Pretrial will be tomorrow, January the 8th at 10 o'clock. You'll be in front of Judge Hessen. And that's it. So you're gonna have to post $1,200 to secure your release. If you post that, great. If not, you'll be brought over. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Young lady, I don't know what they're thinking, but you need to stop doing this. You don't have the right to do this. Good luck to you. Thank you. J. Javon Maurice Yee Neely Bay, 25F243246A and B and C and 25F243946. Where's this gentleman at? Or J. Jawan Yee Neely. Any idea, John?
This year.
Madison Molinari. Madison Gabrielle Molinari, 24WA35562. Good morning, ma'am. Your name?
Madison Warner.
All right. You didn't check in with the prosecutor yet, right?
No, I did not.
So this is a review hearing.
Neely's in the courtroom, you know.
Where's she at?
Ready.
Why didn't you come up here when I called your case?
You said my brother, you said J1. I'm Janaya.
Well, I mean, I can't have you representing. Hang on. Hang on. Okay, so on review hearings, John, we gotta send them over to the prosecutor.
Yeah.
Is he in what, is he at 249?
Yes.
Just get here.
Your Honor?
Yeah, real quick on this Molinari, it's just a review hearing. I'm gonna ask you to take a look at this. We should have had this into you before. My apologies.
No worries.
Thank you. John has it. Thanks. Ma'am, you go meet with the prosecutor and then you'll come back in here, okay? I don't understand. Is Jay Jawan, are you Jay Jawan?
No, that's my brother.
Well, where's Jay Jawan?
No.
Are you here? You're not trying to represent him, are you?
No.
I have two Neely's. I had that one, and I had.
They must have pulled the wrong file. Here, where's Molinari? Give Molinari to Bill, will you?
Hang on, Bill. Hang on. Everybody, sure.
There, we might have pulled the wrong file here, Heather.
Bill.
Well, this is McNally. So that's Mr.
Judge,
Knight.
we do have Jay Jawan under the 840s today, but we also have Janaya on too. We have a lot of G. Neely's on the docket today.
I see.
Steve, did I?
Yeah, so these are not the right files. Charles Lester Laney, 25W39812.
Good morning, Judge. As I get come back from Mr. Neely. Lady, I apologize. I got caught up with the whole thing.
I can't,
Mr. Lane, state your full name.
Charles.
I'm not gonna adjourn this again.
Your Honor, may counsel and I approach
Your appearance,
briefly.
your appearance.
William Neary County City, Whitney.
Why wasn't he here December 10th?
Judge, that was on me. There was confusion as to whether or not.
How was there confusion?
Well, Judge, I was retained on this case way back in September. Originally, they had assigned Mr. Laney to my brother, who was also an attorney, Judge. And the notices were going to him.
Guys, I can't keep adjourning these.
This would be a last, may we approach, Judge?
It's 100 days old already.
I understand, Judge.
Judge?
Very quickly.
Judge, I don't want to end so.
Hang on a second. Okay. John, go off YouTube a sec, will you? Go off the record, please.
Some courtroom moments aren't about the original charge at all. They're about whether someone respects the court process. And in this case, the judge had clearly run out of patience. The hearing centered on a defendant who had accumulated multiple traffic-related cases and, according to the court record, repeatedly failed to appear. As the judge reviewed the history, the frustration became obvious. The defendant had missed court dates going back years, with several opportunities already given to resolve the matter. Instead of seeing progress, the court saw a pattern of no-shows, missed deadlines, and unpaid obligations. When the defendant finally appeared, the judge didn't hold back. He questioned how someone could ignore court orders for so long and then expect everything to be handled casually. The defendant explained that she had moved and lived in another state, but the judge wasn't persuaded. In his view, living a few hours away wasn't a valid excuse for repeatedly ignoring court appearances. He pointed out that modern technology even allowed court participation by Zoom in some circumstances, making the repeated absences even harder to justify. As the judge reviewed the case history, he listed one missed appearance after another. The record showed years of delays, failures to appear, and unresolved matters. At one point, he openly questioned what the court was supposed to do when a defendant continuously ignored orders. His concern wasn't just about the traffic offenses, it was about accountability. Courts rely on people showing up when ordered, and when someone repeatedly fails to do so, judges often view that as a direct challenge to the judicial process itself. Because of that history, the judge determined that a simple promise to appear wasn't enough. He explained that What happens when a defendant ignores court dates for years and finally ends up standing before a judge? In this case, the answer was simple. The judge was no longer interested in excuses. The hearing involved a woman facing several traffic-related matters that had been sitting unresolved for years. As the court reviewed the file, the judge discovered a long history of missed appearances. According to the record, court dates had been missed in 2022, 2023, and beyond. Each time the court attempted to move the case forward, the defendant failed to show up. By the time she finally appeared, the judge had already reviewed pages of delays and unanswered court orders. When asked about the situation, the defendant suggested that moving out of the area had contributed to the problem. But that explanation didn't impress the court. The judge quickly pointed out that people cannot simply move away and expect legal obligations to disappear. Whether someone lives nearby or in another state, court orders still apply. In fact, the judge noted that the defendant had even appeared remotely before, proving that distance wasn't really the issue. As the hearing continued, the judge carefully reviewed the timeline. One missed date became two became four, then even more. The longer the list became, the less patience remained. At one point, the judge... A different courtroom moment showed another side of judicial frustration when a judge confronted attorneys over a case that had already been delayed for far too long. The case had been pending for months, and when it was called again, the judge immediately noticed something troubling. The matter was already more than 100 days old, yet it still wasn't ready to move forward. Defense counsel explained that there had been confusion regarding legal representation and court notices. According to the attorney, some communications had been directed to another lawyer, creating misunderstandings about scheduling and appearances. But the explanation did little to ease the judge's concerns. The court emphasized that cases cannot sit unresolved forever. Every adjournment means more delays for witnesses, attorneys, court staff, and everyone involved. Judges understand that mistakes happen, but at some point, cases must move forward. The judge made it clear that patience was running out. As the attorneys attempted to explain the situation, the judge interrupted and pointed out just how old the case had become. More than 100 days had already passed, and the court was still dealing with scheduling issues rather than the actual legal dispute. The judge stressed that courts have an obligation to move cases efficiently and that repeated postponements undermine confidence in the justice system. Eventually, the attorneys requested an opportunity to approach the bench and discuss the matter further. While the judge allowed the discussion, his message had already been delivered loud and clear. Delays have limits. Judges are often willing to grant continuances when there is a legitimate reason, but they also expect lawyers and parties to be prepared. When a case drags on for months without progress, the court may begin demanding answers. This hearing serves as a reminder that courtroom deadlines matter. Whether you're a defendant, a lawyer, or a witness, the justice system depends on people following schedules and being ready when their case is called. Otherwise, even a judge known for patience can eventually reach a breaking point. Question: